lawyer Sabine Franco, and it's time for Sabine's Common Sense. Sabine's Common Sense question of the day is, do I really need a will since my heirs will inherit when I die anyway? As a New York attorney running a small law firm, I've been getting a lot of estate planning questions, or how I like to call it, legacy planning. Since the start of this 2020 pandemic, which we are in, everyone have been asking these questions. Unfortunately, families are finding themselves in scenarios that come up when poor or no planning takes place as it relates to your legacy or your next generation after you pass. So I'm going to answer one of these common questions about wills that I've been getting over the past couple of weeks. First, let's talk about what is a will. But before I get into that, don't forget to share, like, and subscribe to my channel and click that little bell to turn on the post notifications so you know when I post these weekly videos. All right, so what is a will? A will states what you wish to happen with your assets when you pass and or to select a guardian or caretaker for your minor children. If you die without a will or other planning document, your estate gets to decide who will benefit from your estate, which will be your heir, okay? Here are a few definitions that you need to understand. An asset is anything that you own of value that makes you money or appreciates in value over time. Your estate is the total of anything you have of value or in your ownership or possession, which includes assets and maybe sometimes liabilities. Your heir is your closest living relative who by law, unless you choose otherwise, is entitled to inherit your estate when you pass. Non-heirs are unmarried partners, friends, stepchildren, in-laws, godchildren, ex-spouse, foster kids, a charity, or even your favorite organization. A beneficiary is someone you choose to receive your assets from your estate when you pass. There is no limit to who can be your beneficiary. You can even select your dog, okay? You choose your beneficiary through a will, a trust, a retirement account, a bank account, or a life insurance policy, among other things. You decide who and you decide how much. States vary on the order of how your heirs get to take under your estate. It's usually a combination of first your spouse, then your children, then your parents, then your siblings, regardless of your current relationship with them. For example, suppose one child is wealthy and another not so much. Maybe you want to provide for the non-wealthy child a bit more, right? Suppose one child is estranged, which is just a fancy way of saying that you're done with them or they're done with you for whatever reason. There are so many families that just don't fit the mold of what the law thinks that you may want. There are families who have non-biological children that they raised and for whatever reason could not adopt. Nieces and nephews who are like children. What about children outside of your current relationship or marriage? What about if your children are minor and you have assets that you want to get passed directly to them? Who will protect those and who will manage those funds? You could be separated but not divorced, have an unmarried partner. There's a whole bunch of different scenarios. There are also tax benefits to creating a proper legacy plan, which includes documents such as a will. Don't leave these decisions to your state or a court to decide. You get to decide the outcome if you plan ahead. Before you go, don't forget to share, like, and subscribe to my channel and ring that bell for post notifications. And that's pretty much all for today. You can also leave a comment below. Let me know if this video was helpful and if there are other questions you may have. If I get enough comments or requests, I can make a post about it. That's all for Sabine's Common Sense question of the day. Don't forget to use your common sense, and if you don't have any, feel free to use mine.